Here's a quick overview of your study guide for the Unit 2 Torts Civil Law test. I left all the definitions blank. You can find those in your book and in your notes. Make sure you can define those clearly, distinguish between intentional wrong or tort, negligence, strict liability, and know all the different types. One of the first questions here, for an intentional tort, what are the two types of defamation? One of the types is slander, and that's the spoken. So talking about someone's reputation, damaging it, because you're making false claims. Again, there's always got to be three parties. It can't just be you and the defendant. It's got to be a third party. And then libel is a written expression about a person's actually writing this down, those false claims, and hurting that person's reputation. Now, the three types of damages, compensatory, to compensate for whatever was done, all the harm that was done that was caused by the defendant. Nominal is more of a symbolic award, so maybe $1, just kind of recognizing that the defendant was in the wrong. And then punitive, again, in that word punish, amounts awarded the plaintiff to punish that person, maybe for that malicious or wrongful act. And again, it warns other people and companies not to engage in the same type of destructive conduct. The four elements of negligence: duty, breach of duty, causation, damages. Again, your duty, you owe something, a duty of care to the plaintiff, and if that is violated, then it's a breach of duty. Causation, there's some type of harm done, and then there's damages, so you want to be compensated for those damages. There's actual damages that occurred from the harm. What is the reasonable person standard? This is what the courts and individuals use. It's that average person, that person that acts the way the community expects you to act. Cause and fact: if the harm would not have occurred without the wrongful act, then it is the cause and fact. So it's something if the defendant does that cause the harm, that's the cause and fact. Proximate cause: must be a clear connection between the wrongful act and the harm caused. Must have a foreseeable result. You kind of have to predict that if there's something wrong that is done, you can kind of predict the consequences and the outcome. The two types of defenses to negligence suits: contributory, so you can say that the plaintiff also contributed because of their own negligence, so that resulted in the harm. Or comparative, then you can divide the loss according to how much fault the defendant had and how much fault the plaintiff had. 3 areas of strict liability are dangerous activities, wild animals, defective products. The two elements to prove strict liability are only causation and damages. And it's hard to prove a defense or defend against strict liability because you don't have to prove the duty and breach of duty. That's already there. Those are expected. So only defenses to try to push for a negligence standard, or if it's a product, you can say they misused the product. The last thing here in the Unit 2 is the tort reform. The movement that causes, or that focuses, on changing the process of settling tort claims, making it harder for people to sue in court, whether that is limitations on how much money is awarded, arbitration clauses, but tort reform is making it tougher for individuals to bring defendants to the courtroom.